And just as a reminder, if you are not speaking, I would appreciate it if you would mute your microphone. If you forget, I may mute it for you, so just pay attention to your microphone if you are going to be speaking so we can avoid background noise. Let me just first apologize. I'm having some technical problems and can't pull up all of the documents with me at home. I thought that was going to be seamless. Like so many things these days, nothing seems to be seamless, but we will carry forward anyway. The first item on the agenda is the approval of the minutes from the February 8th, 2021 meeting. Is there a motion for approval? Please state your name when you move something.
Judge Bella, so moved.
Is there a second?
Avery Whetstone, second.
Thank you very much. Are there any changes or amendments to the minutes? If not, all in favor, please say aye.
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 Opposed, say no. That passes unanimously. The next item is 2019-004. It's a proposal from Attorney Natasha Pierre from the State Victim Advocate. We've had this item on several times before, but for purposes of a background information, I'd turn it over to Attorney Del Campo.
Okay, yes. This was last reviewed by the committee at its meeting on November 16th, 2020. At that meeting, Judge Gold indicated that efforts to resolve the Office of Victim Advocate's concerns using forms and the new criminal database rather than rules changes were ongoing, and that the matter was then the matter was tabled until today, March 2021 meeting, to allow time to coordinate those efforts. I believe Judge Gold is here with an update.
Thank you. But I should mention, by the way, just before I turn it over to Judge Gold, that this is our last regular meeting of the calendar year, of the court year, I should say, for the purposes of getting items onto our public hearing agenda so that they can be heard in May, I believe, in advance of the annual judges meeting. So with that background, Judge Gold.
Thank you very much. I really don't have too much to report as to this particular proposal. Mr. Del Campo is right that we had met back, or I reported to the committee back in November that Mr. Colangelo, Ms. Pierre, and I had met. We had at that time agreed to table this pending the implementation of certain other procedures that Ms. Pierre felt would satisfy her concerns and would make a rule change unnecessary. I have not heard anything from Ms. Pierre, and she is not someone who would be shy to reach out to me to report her continued concerns. So I would like to think that the new procedures that were put in place satisfied OVA's concerns and that this matter can go off.
Judge Gold, I believe we have Attorney Pierre on this call. Attorney Pierre, are you available?
Yes, I am.
So my question for you is, do you think that there has been sufficient progress thus far that we can continue this matter until next year to hopefully address all of your concerns without a rule change? Is that feasible?
I do. I'm not sure what is going on because we're just in a standstill right now, but I have received, I have talked to state's attorneys that says that they say they're talking about it. So I don't think we got to a point where we have policies and procedures. I haven't seen it, but I'm comfortable with us, delaying the process, especially considering the time is because we're in, because everything's delayed. We have not, in this time, been receiving a lot of complaints, which is a tribute to, I think, the system really making sure we've seen a lot of extension to victims and some changing of kind of how we do things to make sure victims are included more during this time than before. So I'm willing to wait and see the actual policy and procedure and see how it rolls out on this issue.
I appreciate that, and I would also extend to you my willingness to help facilitate some of those discussions if you need me with the Division of Criminal Justice. I have a different capacity as chair of the Criminal Justice Commission. I'm happy to help facilitate that if you need it.
Okay. I don't see an issue. I think it's just a matter of timing right now for everyone.
Great.
So I think we'll return to this. Things are opening up more, and so I think we'll start to get the concrete things we want to see.
I appreciate that report, and I appreciate Judge Gold's input as well. Is there any objection from members of the committee to table this item for the time being? Hearing none, we will proceed to item 2019-014, the proposal from Senator Looney, Senator Winfield, and Representative Staffstrom concerning pretrial discovery procedures in criminal matters. I know Judge Gold is going to speak to that, but Attorney Del Campo, did you want to give any prefatory remarks?
Well, no, not really. I mean, this was tabled until today so that Judge Gold could continue his discussions with the legislature. There was a revised draft submitted, and Judge Gold can go through that, certainly.
Thank you, Judge Gold.
All right. Well, first, with regard to my efforts to communicate with the proponents of the rule change, at the direction of the committee, I reached out late fall, I think, initially, to speak to Representative Staffstrom and Senators Looney and Winfield about their proposal and certain changes that were made as it was discussed by relevant stakeholders. I initially made phone calls to them. Legislature was not in session at the time. I did speak to Senator Looney, so I know that he was brought up to speed on what the final proposal would contain and was satisfied. At the committee's request, I then sent a letter to all three of them once the legislature was back in session. I think that went out sometime in January. I heard back from Representative Staffstrom, and we exchanged emails, so I know that he's aware of and has no objection to this rule going forward. The last time I reported to the committee, I had yet to hear from Senator Winfield. I thought that might have in part been my mistake because I had misstated the date of the February meeting. So I was, in my communication to him, I was asked again to contact Senator Winfield and also to CC his legislative aide. I did send that letter out shortly after the February meeting. I have not heard back from Senator Winfield nor from his aide. So if the committee wishes me to proceed, I just want it known that I have not yet heard back from Senator Winfield. Chairman McDonald?
Judge Gold, I failed to tell you that about a week or so ago, I had occasion to be speaking with Senator Looney about something else, and I mentioned this item. He said he was going to check with Senator Winfield, and if there was a problem, would get back to me, and I have not heard back from him either. So I'm at this point taking silence as acquiescence, I guess. I don't think there will be any objection. Now, I want to make sure everybody is focused on the same document. Attorney Kassebaum sent around a slightly revised document on March 11th, and I know she is on this call as well, or this meeting, and I didn't know if she wanted to address any of the revisions that were included in the March 11th version of this document. Attorney Kassebaum?
I'm happy to address anything you'd like. I don't know if Judge Gold wants to say anything ahead of time, or you want me to just...
Well, I mean, I can sort of summarize, if it's all right with you.
Sure.
Donald, I'll summarize what this rule change is intended to do. I agree with you completely. If we get down into the weeds, I'll be quick to call on Kate to get me out of them. How's that?
Sounds good.
I think the overarching purpose of this rule change is to speed up the discovery process and ensure that the defense has access to all discovery early enough in the process and far enough in advance of any trial so as to take advantage of the information provided and be prepared to address it if the matter goes to trial. So that, I think, is the overarching purpose of the changes. Now, I think more specifically, the changes are directed to three things. Number one, as a incentive to cause prosecutors to respond in a somewhat more timely fashion to discovery, we have changed the rules so that continuance requests from the defense that are necessitated by virtue of a prosecutor's failure to diligently comply with his or her discovery obligations will no longer be excludable time from the speedy trial requirements. So for the non-criminal practitioners on the committee, it had generally been the rule prior to this proposed change that if the defense was the moving party for a continuance, that was excludable time from the speedy trial. So a defendant was often sort of betwixt and between. The defendant may want additional time to get discovery, but in doing that would be sort of agreeing that that time it would take for that discovery to be provided would not count against speedy trial. Now, I should say, in fairness to the prosecution, the obligation of prosecutors to comply with discovery is not always an easy one because none of these materials in the first instance are in the state's possession. So the prosecutors are tasked with the responsibility of reaching out to other agencies, many of whom sort of work on their own time schedules, in collecting the information that has to be statutorily and constitutionally turned over. As a former prosecutor, frankly, I can say that sometimes is a more difficult task than it might at first blush appear to be. So in suggesting that we're changing these rules as an incentive to prosecutors, I think in the main, the prosecution throughout the state uses great diligence in attempting to respond in a timely manner to discovery requests. And while it will no longer be excludable time if the prosecutor has not been diligent, it will continue to be excludable time if the prosecutor is exercising due diligence in attempting to assemble the materials that must be turned over. I suspect in the more contested cases, that issue of whether or not there has been due diligence might come to a court's attention, and the courts are just going to have to rule on it. But so that's sort of the first thing we've tried to do. And if
Can I just add one more thing, Judge?
Yeah, please, Kate.
We also a lot of this was put together by a subcommittee that the Rules Committee initially tasked with tackling these requests. And one of the other things was to include authority for the court to issue subpoenas to outside agencies on its own motion if the prosecutors are having trouble getting materials from these outside agencies. The court in the current rules is essentially limited to when someone files a motion asking the court to issue a subpoena. And so if the court thinks that that the prosecutors have done the best they can trying to get these outside agencies to comply, the court can actually issue a subpoena to kind of put a little more fire under the outside agency to keep things moving along.
Thank you very much, Kate. And please don't hesitate to add additional information as I move forward. Just for the committee's benefit, the expansion of subpoena power to the court appears in 40-2, which is one of the sections that has been forwarded to you for possible change. And the changing of the speedy trial exclusion is a new section, which is section 43-40 large A, which, at least in the way I printed out Kate's March 11th letter, might be page 5, the fifth numbered page in the materials that hopefully are before the committee members, but it is 43-40A. So that's sort of part 1 of 3. The second part of these rule changes goes to the plea bargaining process and how discovery relates to that. As I mentioned before, the overarching theme here is to make sure discovery is available at a time it can be taken advantage of by the stakeholders. There had been a concern that at times defendants were contemplating plea negotiations before the defendant had had an opportunity to get access to all the discovery. That concern has led to a significant change in section 39-18 of the materials. In 39-18, the proposed change would obligate the court before accepting a plea from a defendant to inquire of the defense as to whether or not all discovery sought by the defense had been turned over to the defense by the prosecution. Now, I know that in Kate's letter to all of you, it indicated that there were a few what were called Judge Gold edits. When this came to my attention in the fall, a lot of this had already been negotiated prior to the time I became the CAJ, and I had not participated in that. I had some concerns about the language in 39-18, and since I did take over in the fall, I've met with all the stakeholders again to tweak some of the language. So 39-18 is a somewhat edited version of what had originally been submitted to the Rules Committee a year ago now in March of 20, before the pandemic sort of stopped everything in its tracks. So under the current proposal, the defense will have the right to, in essence, waive its right to get full disclosure if it wishes to go to plea before getting everything. So when the rule was initially being contemplated, it said that a judge can't take a plea unless the defense says, I got all discovery. It was actually the defense that said, we're not crazy about that, because there's plenty of cases where we would like to plead before the prosecutor knows what's in all the discovery. It may be in our client's advantage to do that. So we have now allowed the defense to waive its right to receive whatever it is it hasn't yet received and go ahead with the plea. The court, without this tweak, the court would have been in a position of saying, I can't accept the plea, period, unless you say you've got it all. Now the defense can actually waive that. That led to actually a follow-up. I'm sorry, go ahead, Justice.
Can I, before you get too much deeper in it, can I ask you a question on that?
Yeah.
For the waiver, it says the defendant and his or her attorney. Do both have to agree? Is it a personal constitutional right, or is it an evidentiary right that an attorney can do versus the defendant him or herself?
It's a good question. I actually can't say that it was a subject of any discussion. I do see the word And is there, I'm trying to think if, Kate, do you remember Ann versus Orr or?
I honestly, I don't think that there was any substantive discussion about
I don't,
the and there.
I mean, it's certainly a safe thing if the defendant himself waives it, but can an attorney waive that on behalf of the defendant? I don't know.
Well, maybe that's why it's Ann, just to make sure that we're not creating something that you will tell us we were wrong on.
Okay.
I'm not sure.
I'm sorry to interrupt it.
No, and I'm being facetious, of course. I don't remember it being discussed, and I don't know whether or not one side, maybe there were some stakeholders that actually wanted it to say that, but I don't remember any specific.
Sorry to interrupt.
But no, not at all. The last sentence of 3918 as proposed will ensure, however, that even if there is a defendant who wishes to go forward, the state will still have a continuing obligation to disclose exculpatory information that may come to its attention at a later date. This whole provision, although it's a sentence or two, engendered quite a bit of back and forth, and this is certainly in the nature of a compromise. So that's really the second area of the rule change with regard to pleas, and the
Can
third.
I just point out one other thing, Judge? Sorry. In the proposed changes in 39-7, in the final subcommittee recommendations, there were brackets at the end of that provision that were a mistake on my part. Those should not have been included. So it's because they're just little brackets. I just want to point out that that those should not be there. So
that language remains.
That language would remain. Yes.
Thank you.
All right, and thank you, Kate. Finally, as I mentioned, one of the concerns was defendants who received discovery somewhat at the 11th hour and then are told that trial will be starting in relatively short order and perhaps without enough time to respond to, prepare for, or come up with a defense strategy to address this late disclosed material. So the changes we've made in 4415 will require, absent a contrary demand by the defendant, that there be at least 45 days after the last discovery is provided before the trial could start. It also makes clear that material discovery turned over once that trial date is set, 45 or more days out, anything that's disclosed once that date is set would warrant either a further delay or possibly the exclusion of the late disclosed evidence from the trial, as well as other remedies that are set forth in 40-5, which, is that right, Kate? It's 40-5 that has the sort of the sanctions or remedies?
Yes. Yes.
Okay. So that's the third part of the rule.
Thank you. First of all, Kate, you had mentioned to me in a conversation about a extraneous bracket that shouldn't be there.
There's another one. Yep. At the that's on at the end of subsection or new subsection D on near the top of page 9. There's an extra bracket there too that I didn't notice, and yeah, that should not be there.
Okay. Thank you. Attorney Del Campo and his staff will take care of that. Just two questions, maybe just two questions for you, Judge Gold. The first is with respect to, I'll go in reverse order here, on page 10 of the document, It just struck me as somewhat odd that if the amount of electronic information exceeds normal file capacities, it's the receiver of the information who has to provide the storage capability to receive the information. Why is that?
All right, well, may I just comment, because I hadn't gotten to 40-6 yet about.
Oh, I'm sorry.
But I will.
I apologize.
No, that's fine. The final provision, and this is something that we actually put together quickly in the fall, I guess. And it comes out of really the pandemic, when some of the lawyers didn't want to have to come by the courthouse to pick up the discovery that had been photocopied by the prosecutors and left at the prosecutor's office. And discussions started, why can't we get this stuff electronically? As a sort of the default setting would be that all discovery is provided electronically. I will say that Mr. Colangelo and his representatives embraced that idea as soon as it was mentioned, and it has resulted in 40-6 sub B, a new subsection that will require all criminal discovery to be disclosed in an electronic format unless the parties agree to the contrary or the court orders to the contrary. Now, what Justice McDonald just mentioned regarding the second sentence, or the last sentence anyway, of the subsection, the new subsection B, I know that Mr. Colangelo, as I recall, brought that up for certain cases. The size limits of the discovery might require some sort of electronic storage medium to be utilized. And there was very little objection to this provision as was proposed. I don't know, Kate, do you remember any defense objection to?
No, and in fact, Attorney Rapillo was part of the conversations with that, and she said that that's how things have been working all along. That if they're, for them anyway, that if there was something that was too big to email, they would come over with a thumb drive and get the materials that way. And from Attorney Colangelo's perspective, that's, I mean, they're not in the business of, buying or giving out thumb drives, and so it's just there. And the rules generally say that they have to make things available for inspection and copying, but it doesn't say that they have to, outlay expenses to, provide that stuff. So, so this was just a way to, and the criminal practitioners were involved in that. So, both the public defenders and the private practitioners. So,
I appreciate that. I won't dwell on it any further. I'm just certainly not going to try to change anything here. I will say that this barely brings us into the 20th century, much less the 21st century. There are so many different versions of secure cloud sharing applications that are used in litigation all over the country to share hundreds of thousands of documents so that people aren't running around with thumb drives, which are not exactly secure. I guess we can address this in some future rule. I don't need to delay it here, but that seems to not go far enough.
Your Honor, if you, just to mention that as part of the prosecutor's new criminal case management system, I think that there is going to be a way to do an electronic kind of cloud file share where they'll send a link to materials somewhere that live in the cloud, and the attorney or the defendant can click on the link that's specific to them and access the materials that are specific to their case. without having to, cart around portable electronic storage. So,
Okay, thank you. And Judge Gold, my other question was on page 9 at the top in subsection D. And I'm not suggesting that we do anything today, but this section, as I understand it, deals with the late disclosure of discovery. And it says that that in the event that there is late disclosure of discovery, the opposing party may move the judicial authority for an order to either grant a continuance or limit the introduction of the evidence. And you probably are aware of a case that I authored in State versus Jackson, where this was exactly the issue. And there was a disclosure of an expert witness after voir dire had begun, and the defendant sought to have the expert not introduced or to have a continuance, and both were denied, even though it was in the middle of trial, basically. And so there's nothing in here that says that if there is late disclosure of relevant discovery, that the court shall grant a reasonable continuance or limit the evidence. So is that a gap in this language? And if so, is that something we should address in the future?
Well, it's a gap in the sense that it isn't expressly stated. So I guess in that sense, it is a gap. And certainly if it's believed by the defense that even notwithstanding Your Honor's decision, that judges are either denying requests for continuances or exclusion, or not granting a long enough continuance to prepare for the late disclosed evidence, I suspect the rule can be revisited. But I'm hopeful that the rule as drafted, together with the court's clear preference in the Jackson case, that the trial court will recognize the need to give the defense ample time to prepare for anything that's disclosed later than it should have been. Okay.
I mean, these changes, first of all, these changes are very substantial in their own right. And it's not to say that everything that could ever happen could be contemplated. So I guess we will see how they work in the real world. And if there's a problem in the future, we can readdress it. I appreciate those answers. Are there other questions from members of the committee? Seeing no hands and hearing no voices, is there a motion to approve these changes in 2019-014 with the small administrative items that Attorney Kassebaum has referenced?
So moved, Judge Bellis.
Been moved. Is there a second?
Second, Judge Cobb.
It's been moved and seconded. Is there any discussion? If there's no discussion, all in favor, please say aye.
Aye.
Aye. Aye.
Opposed, say no. That passes unanimously, and with the gratitude of the committee to Judge Gold, to Attorney Kassebaum, and to everybody who participated in the process over a fairly lengthy period of time to build a consensus product. I do appreciate your work.
Thank
Your
you.
Honor, can I make one more point?
Sure.
I'm sorry.
That's
So,
all right.
So originally there were 5 requests from the legislators, and the changes that Judge Gold outlined for you addressed the first 3 requests. In the initial submission to the Rules Committee back in January of last year, in document 29014H, there was also a recommendation from the subcommittee to not make any changes with respect to the requests number 4 and 5. And I didn't know if that was something that the committee needed to officially vote on to not take any action with those.
No,
Okay.
it's the item that was before us was as revised by and presented by Judge Gold. And you covered those items in your cover memo, which I appreciated.
Okay,
Thank you.
you're very welcome.
The next item is 2020-014, proposal from Faiz Siddiqui to amend section 36-6 regarding cancellation of warrants. Attorney Del Campo.
This is a first time being considered. Attorney O'Donnell is going to just run through the little bit of a history that we have here. if
So
that's
this
okay.
proposal was originally sent to the appellate court, and it was forwarded to the Rules Committee for review based on Mr. Siddiqui's request that Section 36-6 of the practice book be amended. The current Section 36-6 specifies that a prosecuting authority or the judicial authority can start the process to cancel a warrant that was not served. And this was an issue in Mr. Siddiqui's case where he had wanted to file a motion as the defendant to ask that a warrant be canceled and was told that the practice book did not allow for such a procedure. So he, on page 3 of the PDF of the materials, is proposing new language to give the defendant the option to file a motion to ask the court to consider canceling a warrant that has not been served. At the time that this proposal was originally sent, Mr. Siddiqui did have cases pending in the appellate court, was possibly waiting to appeal to the Supreme Court, but those issues have all been resolved and there are no cases pending with the appellate or Supreme Court currently.
And I should note that when that item came to the Supreme Court, I recused myself from that case because Mr. Siddiqui had contacted me in my role as chair of the Criminal Justice Commission, and I had correspondence with him as well. You know, I don't, Attorney O'Donnell, do you recall how the appellate court actually disposed of his case? Was it dismissed?
I believe that the case was dismissed, and then Mr. Siddiqui did try to get searched to the Supreme Court, had several extensions of time, and was eventually denied.
What I'm saying is I seem to recall that there was an issue about whether or not there was even jurisdiction to take an appeal because he had not been served with a warrant, and therefore the case had not been begun from the court's perspective. We don't need to get into it, but the issue that we are being faced with is should the individual who is the subject of the warrant have an opportunity to ask a court to exercise its own authority to cancel a warrant. And I don't know if there's any appetite among the members of the committee to seek additional information from any of the various stakeholders who might be interested in this matter. So I'll open up the floor for any comments.
Justice McDonald, it's Judge
Yes.
Cobb.
Yes, Judge Cobb.
Yeah, I guess when I looked at this and I looked at the case, the appellate court case, I was wondering whether we could even, if we wanted to, address this by rule, since the appellate court determined that the court lacked jurisdiction because the case had not yet been initiated. Therefore, the court wouldn't have jurisdiction to address such a motion. And if that's the case, then I don't know how we could fix it by rule. It might have to be statutory.
I mean, it's an interesting issue. The court, according to the rule right now, the court could do it sua sponte. The question is whether or not someone could, I mean, how would a court have the initiative or have the reason to cancel it unless somebody has brought it to the court's attention is the issue. And the question is whether or not somebody who is a subject of the warrant has could bring it to the attention of the court so the court could determine whether to exercise its inherent authority to cancel a warrant.
Right. And it seemed like that issue was addressed that the court wouldn't have jurisdiction, which I thought was unusual because, I mean, certainly the court signs the arrest warrant and finds probable cause, right? So we are taking action in some capacity prior to the case coming to court. And when we sign those warrants, the case isn't initiated yet. It's kind of complicated. And then but I agree with you, like, and I have in my experience have had prosecutors bring warrants back to me and asked me to cancel them.
There's, I don't hold me to the number, but there's tens of thousands of unserved warrants. And I would think, I'm not a criminal expert, I would think there should be a process or an opportunity to bring it to the attention of the court to cancel warrants other than by the prosecutor, but maybe I'm wrong.
No, I mean, I don't disagree with you. I guess my point was, I was thinking about, as I read the appellate court decision saying there was no jurisdiction, then how could we cure it by rule, even if we wanted to? I mean, as a judge, if you signed an arrest warrant and it turned out that information in there was not correct or something, and somebody wanted to bring that to your attention, since you signed it, it seems like you should have the opportunity to hear it. But I'm concerned about this jurisdictional piece based on the appellate court decision.
So given the fact that this is our last meeting for regular items this year, I would propose that we have our legal staff look at this over the summer with the opportunity to reflect on some of the issues that are identified in the appellate court case and the practical concerns of whether or not somebody other than the prosecutor could initiate the process. Is that acceptable to members of the committee?
Yes.
All right, hearing no objection, we'll proceed in that fashion on that item for now. The next item is 2021-004, proposal from the Connecticut Bar Association to revise Rule 1.8 of the Rules of Professional Conduct. Attorney Del Campo?
Yes, this was on February 8th, on the agenda February 8th. After full discussion, it was pointed out, or I pointed out actually, that it was somewhat unclear as to which iteration of the proposed amendment was being considered, because there were several attached to the CBA's proposal, some which were attached to the model rule, some which were attached to our current rule, and ultimately you tabled it to this meeting such that the CBA could take a look at it and get back to us. Attorney Stovall did take a look at it, and she has gotten back to the committee with the which version was the proper iteration, and that's attached to this proposal today. I think Attorney Stovall is on the call as well. But what you have attached is the proposal that is to be considered, was discussed. We just wanted to clarify because there were certain differences in the language.
And you're talking about item C, right? Is the clarification?
Item C. So I'm talking about, yes.
Okay. Attorney Stovall, is there anything you want to briefly address?
Yes, first I'd like to apologize for having made mistakes in juggling the model rule version with the current Connecticut version, but I believe it's the version that was at tab B of my February 1st letter to the committee that is the current proposal. That's the entire, because that one came off the Connecticut version of the rule and I made the changes on that. So I think that was attached to my email with Mr. Del Campo earlier last week.
Are there any questions for either Attorney Del Campo or Attorney Stovall? If not, is there a motion to approve item 2021-004 as clarified?
So moved, Judge Bellis.
Thank you, Judge Bellis. Is there a second?
Thank you, Judge Bellis.
And it's been seconded by Judge Cobb. Is there any discussion from members of the committee? If not, let me just make sure no hands are up. All in favor, say aye.
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 Opposed, say no. That passes unanimously. Next is item 2021-005, a proposal from Attorney Petrozelli to amend Title Section the title of section 17-45. Attorney Del Campo or Attorney Petrozelli?
This change is to the section to make it consistent with amendments that were made in January of 2017, actually, which eliminated provision for filing a request for extension of time to respond to a motion for summary judgment. Attorney Petrozelli found these in her research, and we just need to make this consistent with the rest of the practice book. It's a little more substantive than we would normally take up independent of the committee. So here it is.
So here it is. Thank you. Judge Bellis, would you care to move this item?
So moved.
Judge Cobb, would you care to second this?
Second.
Thank you. Is there any discussion from members of the committee? If not, all in favor, say aye.
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 Opposed, say no. That passes unanimously. Next is 2021-006, another proposal from Attorney Petrozelli to amend references to the MPRE in section 2-13A7 to be consistent with amendments to sections 2-8 and 2-13. I don't know is there anything substantive we need to hear, Attorney Del Campo?
No, I don't believe so. It just
Okay.
needs to be-
Then I would hand the floor over to Judge Bellis for the purpose of a motion.
So moved.
She's our official mover. Judge Cobb, is that a second?
Second, yeah.
Is there any discussion? All in favor, say aye.
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 Opposed, say no. That passes unanimously. Next is item 2021-007, proposal from Statewide Bar Council Bowler on behalf of the Statewide Grievance Committee to amend section 3-35G in support of efforts to conduct hearings remotely. Attorney Del Campo?
Basically, this proposal, and Attorney Bowler is here for questions, but this basically came about because the branch obviously is moving to have more virtual hearings and proceedings. It was noted that this particular rule requires members of the reviewing committee to be physically present at all hearings. That would not allow these hearings to go forward virtually. So it is being suggested that that language be amended to provide that reviewing committee members shall be present at hearings, which would presumably include or is intended to include virtual presence. Again, Attorney Bowler, I believe, is on the call. If you have
Attorney
questions.
Bowler, is there anything additional that we need to know about?
No, Your Honor, just in the original agenda, the rule was cited as section 3-35G. It's actually section 2-35G.
Yeah,
That's
we
just,
did correct that at some point.
I'm
No.
working off an old version of the agenda. I apologize.
no, I don't have anything to add to Attorney Del Campo's comments. He summed it up very nicely for us.
Thank you. Do any members of the committee have any reason why we can't act on this now, or should this be shared with anybody? Any strong views? No strong views. Then Judge Bellis?
I'd like to make the motion.
And is there a second from Judge Cobb?
Yes, a second.
Thank you very much. Is there any discussion from members of the committee? If not,
I do have one question, Your Honor, of Attorney
Yes.
Bowler. I don't know that if this is a situation where the protocols are being established such that these proceedings can move forward virtually, and to the extent that you want this rule to be moved forward more quickly than is typical, which would be January 2022.
Well, yeah, we would take anything we can get on that point at the moment, Attorney Del Campo. We have scheduled our first virtual hearing for April. It's a hearing where we will not get any objection to a virtual hearing versus an in-court hearing, because we have, of the 150 case backlog at my office right now, we have several that are agreements and motions, essentially nollies by the Chief Disciplinary Counsel's office. And we plan to handle those first because we don't believe we'd get any type of objection from the parties over this word. I mean, we're prepared to argue that virtually present and can mean physically present, but if we could have this rule go into effect, can it go into effect as early as a certain time period after the rules are published in the Connecticut Law Journal?
Yes. Typically, it is 60 days after promulgation, but if the Rules Committee recommends, then the judges can waive that, and it can be effective basically upon publication.
I'd only say to the Rules Committee that we will quickly run out of these agreement cases and motions to dismiss and start getting into contested cases. And I am concerned that the savvy respondent might argue that physically present actually means being in a courtroom as opposed to using Teams or similar video conferencing software. So I would urge the Rules Committee or the judge of the Superior Court, I suppose, to make the rule effective on promulgation if possible.
I think I am sensing an amendment from Judge Bellis in her motion. You're muted.
There we go. Yes, I'd like to move that amendment.
And Judge Cobb, do you accept that for your second?
Yep.
Thank you. Is there any discussion from members of the committee? If not, all in favor say aye.
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 Opposed say no. That passes unanimously.
Thank you.
The next item is 2021-LSS, recommendations for reappointment of members of the Legal Specialization Screening Committee. Attorney Del Campo, I don't have these materials in front of me, so if you could walk me through it, I'd appreciate it.
Okay. 7.4B of the Rules of Professional Conduct requires the Chief Justice to appoint and reappoint members of this Legal Specialization Screening Committee. Attorney Payne is the chair of that committee. Her term is up the beginning of the summer. Attorney Dwyer is a member of the committee. His term is up, I believe, the same time. The Rules Committee is being asked to recommend to the Chief Justice that these individuals be reappointed. They have accepted that. We have contacted them and they are willing to serve again another 3-year term. Upon appointment by the Chief Justice, if that comes, the Rules Committee is required to designate the chair. And since Attorney Payne is chair, I assume you would want to redesignate her as that. So if you want to do that now, we will just tell the Chief Justice that if he chooses to reappoint her, then she has been designated as the chair.
Thank you. Before we get a motion, is there any questions for Attorney Del Campo about that? It sounds like we're doing two things in one, both recommending that the Attorney Payne and Attorney Dwyer would be reappointed, and that we would also recommend that we appoint the chair, right? Is that right, Joe?
You designate the chair, yes.
And that upon reappointment by the Chief Justice, that Attorney Payne would be designated as the chair. Is there a motion to that effect?
Shockingly, I'd like to make that motion.
Shockingly, I'd like to second it.
We like frequent flyers. Thank you very much. Is there any discussion? Seeing no discussion, all in favor say aye.
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 Opposed say no. That passes unanimously. And unless there's any further business, anything further?
There is, Your Honor. I have some, please.
Okay.
Just want to make mention that all matters that have been recommended by the committee will go to public hearing after this meeting. The public hearing is Monday, May 10th at 10 a.m. That's different than the 2 o'clock, obviously, but it's always at 10 a.m., just so you can note that. The other thing is that any matters adopted previously by the judges on an interim basis must go to a public hearing. So there are several that were adopted last year that have to go to a public hearing, some of which may be of the emergency nature. We have to look through those. There are several votes that happened last year that were very intricate that Justice McDonald put out there and the judges voted, adopted. So anything that has to go to a public hearing will go to a public hearing, in addition to anything that you're recommending this year, go to a public hearing. I just wanted to remind you of it.
Thank you. And when you have an opportunity, if you could, once you assembled the list of what is going to be at that public hearing, if you could send it out to all of the members of the committee so we could put it back into our short-term memory, I would appreciate it.
Yes, I'll do that.
All right, but before we adjourn, I just want to take this opportunity at our last regular meeting to thank Attorney Del Campo, Attorney O'Donnell, and Attorney Petrozelli for all of their support for this committee. It makes our job substantially easier. In fact, I don't think we could do it without their help and guidance and counsel. And on behalf of the committee, I want to thank each of you for a stellar job under very extraordinary circumstances this year. Having said that, is there a motion to adjourn?
So moved.
Judge Cobb? Is that, all in favor, say aye.
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 Opposed, say no. We'll stand adjourned. Thank you, everybody, and stay safe.